Okay, it's 12:01, so I think we'll go ahead and get started. Welcome to our family webinar hosted by Region 10 ESC and also Partners Resource Network. My name is Sarah Untersee. I am the School Family and Community Engagement Consultant here at Region 10. We are so happy to have Jim Wright with us as well from Partners Resource Network. And our presentation today is about Manifestation Determination Review, or MDRs. And we have Letitia Stevenson with us today. She is a Region 10 school psychology consultant, and she is going to be presenting. Thank you so much, Letitia. I'm going to turn it over to you.
Thank you. Yes, I am the school psychology consultant. I recently left the school spheres, so this is all very relevant to my field as a school psychologist, but it's also something I interacted with a lot with parents and families in the districts that I served. So I'm very excited to get to talk about MDRs today. So let's go ahead and get started. So again, this is just an introduction to me, so you know who I am. And we're going to go over a lot of the legal requirements of an MDR, what it means, and all of those things. It's sometimes can be a little daunting for anyone to enter an ARD meeting when you're going to be doing a manifestation determination review. Usually a student has engaged in a behavior that is unexpected and is concerning. And so there are a lot of people that could be involved. And I just want to make sure that although I talk about a lot of the legal things, I talk about it in a way that's very understandable. Because anytime you interpret, you take law and you try to interpret it, you can do as much interpretation as you want, but it can still be very confusing. I've had a lot of practice talking about MDR, so I'm hopeful that I can make this fairly easy to understand. A manifestation review, or an MDR, in special education, we have our own language, and so we go by a lot of acronyms. So it's an MDR, a manifestation determination review. It is just a review conducted by the ARD committee when a discipline removal is proposed that would result in a change of placement. That's a lot of words. Basically, when a student engages in a behavior that could lead to out of placement, and out of placement could be out of school suspension, and it could also be being sent to an alternative school or an alternative setting. So the manifestation review is just to review that behavior and to answer a couple of questions, and we'll talk about that. Now, there are a couple of instances that can lead to an MDR in regards to timing. So if you have a student who has been suspended, usually out of school suspension, over a total of 10 cumulative days in a school year, then a MDR is required. So you could have a student who in September is suspended for 3 days, and then in October or November is suspended for 2, and then every couple of months is suspended, and then by April they have met that 10 cumulative days. You have to do an MDR, because then the student's going to be out of placement for more time than the federal government thinks is allowable. The other timing issue that we encounter is when a student engages in a behavior that is so significant, it's going to result in a placement in an alternative setting for more than 10 days. So this could be fighting, it could be something related to drugs or alcohol, it could be related to anything that's very, very concerning and very significant. And so when that happens, that's an instance where even if it's just one incident, the ARD committee must meet to determine whether or not the behavior in that incident is related to the disability, and to answer a couple of questions, okay? It's sometimes schools will plan for MDRs, like we'll start talking with parents ahead of time about, okay, they've been out of school with suspensions for a few times now. When we hit 10 days, this is what could happen. And so they may just be informing you. Just because they're informing you if they've been out of placement for 6 or 7 days doesn't mean it will happen. They're just wanting to make sure that you're aware that it could happen. Okay. Sometimes parents get a little bit confused by that. And so I know I've had to clear that up a couple of times. So as a review, a manifestation is just reviewing the behavior that has occurred that is resulting in a change in placement or being out of school without receiving services. It's really important, though, that school districts and ARD committees and parents are aware that there are some timelines involved that allow parents to have notice and to be active participants in that meeting. So they are required to follow the notice, the 5 days notice that you would for any ARD meeting. So what does that mean? That means that if Johnny engages in a behavior on Tuesday, the ARD committee has to give you notice that you have to have that meeting, that MDR, and they have to give it with 5 days at least before the meeting. So they can't have the MDR on that Thursday or that Wednesday or that very same day, unless you give permission for that. But parents have the right to have 5 full days notice before a meeting. And schools sometimes want to have the meeting right after they have, they talk about the behavior as far as like student code of conduct and gen ed stuff. And that's understandable because often the parents are already there or they're participating by phone. But you should be aware that you have 5 days, you're allowed 5 days notice. So keep that in mind. But on the flip side, there is also a timeline in regards to when that meeting can occur or has to occur. So the MDR must be held within 10 days of when they decide what discipline action will occur that would result in a change in placement. So let's say the student engages in that behavior on a Tuesday morning, and the principal does their investigation to find out what happened. And they say, okay, this student is going to be sent to the alternative school for, I don't know, 15 days, let's say. Well, now you have to have the MDR and you have 10 days from the time that the principal made that decision to have that MDR. So sometimes it can take a little bit of time to get that ARD committee to come together, especially if the parents need that full 5 days notice, or if there are a lot of moving parts involved, a lot of people who need to be at that meeting. So we do have to have that meeting within 10 days. So when we meet as an MDR committee or as an ARD committee to determine if that manifestation is related or not, there are 2 questions we have to ask. One is, did the behavior or is the behavior related to that identified disability? Does it have a direct or substantial relationship to that disability? The second piece is whether or not the conduct in question, so did that occurrence happen because the district failed to implement the IEP? Did they fail to use that BIP that's on the IEP? Did they fail to offer or use those accommodations? Did they not, gather progress monitoring information? There are a lot of different things of the IEP that could be related to behavior, but they have to ask, is this on the fault of the district or the school for not providing the IEP? And the parents have the right to ask questions to find out, is this a contributing factor? Was the BIP followed appropriately? Were all of the teachers trained in the BIP? Things like that. And so that's one point that parents can be really engaged in this meeting, is to be able to ask those questions, because you are there advocating for your student. And oftentimes the school district or the school will be like, yeah, we have all of this data and to show that we have been providing the IEP. So, you can ask for that. That is perfectly within your right to ask if you have, documentation to show that every teacher had access to the BIP and so on and so forth. But those are the two questions that are going to be asked as part of the MDR. That's the main part of an MDR, answering those two questions. Sometimes other things come up, and we'll talk about a couple of those things in just a little bit, but this is the purpose. This truly is the purpose of the meeting. And it's really important for us to be able to look at all of the data that's available and all of the information that's available to make sure that we can answer these questions accurately, because it's not fair to the student if we don't. And I talk about that all the time with my school psychs and within my trainings, is you need to make sure you have all the data that's available to make these decisions, because you are really going to be impacting the students' access to curriculum, being able to stay on campus, and so on and so forth. So the committee is going to maybe have some discussion points to be able to answer these questions. They may ask why the behavior is or is not a manifestation of the student's disability. Fair question. Some behaviors you're like, that's clearly not related, and everyone, parents, teachers, principals, school psych, all agree. And sometimes it takes a little bit more investigation to make that determination. So we need details and we need context in order to evaluate whether the behavior was caused by or had that relationship to the student's disability. It should not just be a, well, was it a manifestation? No, I don't think so. If you're saying no, you need to have the data to support that. If you're saying yes, you need to have the data to support that. And then if the IEP was not implemented, the ARD committee needs to analyze whether that failure of implementation caused that misbehavior. So if they failed to implement that IEP, did it cause that misbehavior? Now, there are some instances where a student engages in a behavior that has never been seen before, is completely out of the blue, even to the parents and to the teachers. And so they implemented the IEP effectively, but there was never any concern to begin with regarding that behavior. So they didn't have an IEP to address that behavior. So if you have a student who has a learning disability and has never had any acting out behaviors before, there's never been a concern in regards to anger or anxiety or depression, there's never been anything like that, and then suddenly they got into a fight, and then maybe they've never even had issues with social interactions and things, and then the student got into a fight, takes everyone by surprise. The school implemented what the IEP they had, because they created that IEP based off of student need and all of the data collected. Parents agreed and were happy with the IEP, but then this behavior occurs. It's not because they didn't implement that IEP in that instance. So that happens sometimes. You have a behavior out of the now that may mean that we need to do further investigating on, well, then why is this behavior happening now? That may happen. But if there's never been any inkling that this behavior could occur with this student, then we can't say that the IEP failed, especially if parents are just as surprised. For the most part, when we're dealing with MDRs, there's never one MDR that's the same as the next. It's just like with any IEP, it's individualized, meaning students or people, they have emotions, they have reactions. And so the way that we are able to look at behavior is going to be dependent on the student themselves, which is fair. You don't want to put the same standard in regards to specific behaviors on every student, because it's going to depend on the situation. Like every student's IEP is going to be different. So the behavior in question in relation to that IEP is going to be very different. I don't know if anyone would want something to be just unilaterally the same for everyone, because we have IEPs for a reason, because that doesn't work for every student. So we also need to consider any other relevant information that is in the student's file. So this includes the IEP, but also teacher observations, any information provided from the parent, anything that looks at discipline history or absences or details of the event. Sometimes, when we're investigating, we have an idea of what the event is, but through investigation, we find out a little bit more of maybe what happened leading up to that incident, and then what happened afterwards, what was going on around that student that day or that week. It's really important to make sure that we have that context of the behavior. And so sometimes that means that the parent has to speak up and advocate and make sure that you are asking questions like, okay, when did this happen? What was going on beforehand? Has any of the teachers noticed any changes in behavior or attitude or emotions prior to the incident? That's really important to ask. So if the ARD committee determines that it was a manifestation, if you answer yes to the first question, was it related to the disability? And or you answered yes to the question, did the school fail to implement the IEP, which directly related to the causing this behavior, then it's considered a manifestation. So if you have a yes on either or both of those questions, it is a manifestation. And now the question is, and what do we do now, right? So if it's yes, the student must be returned to the placement from which they were removed, unless there are specific circumstances in which that is not allowed by federal law. The incident involved weapons, drugs, or severe and significant bodily injury. The other exception is when the parent and the school both agree that a change of placement as part of the modification of the BIP is appropriate. So there are some instances where the school, the ARD, everyone in the ARD committee, the parent agree that while it's a manifestation, a change of placement would be a good intervention for this child. Sometimes that is the end result. But what happens if the behavior is determined to not be a manifestation? That means that the student may be disciplined in the same manner and for the same duration as a child without a disability. What does that mean? Follow the student code of conduct. So if it's not a manifestation, that's what happens. If it's not a manifestation, the ARD committee then has to decide what's an appropriate interim alternative setting, like what's the appropriate discipline setting? Is it an alternative school? Is it another 3 days of out of school suspension? What's a good a discipline environment and setting? And they must be able to determine whether or not a free, appropriate public education can be provided in that setting. Every child has the right to a free and appropriate public education. And so the ARD committee has to determine what that looks like for each student and how can they provide services within that. So sometimes MDRs lead to or end in disagreement towards the end, but sometimes in that first meeting, the ARD committee can't come to consensus about those two questions. Sometimes the parents don't agree with what the school is presenting. Sometimes the school doesn't agree with what the parents are presenting. Sometimes there's just a miscommunication. Sometimes there's a lot of emotion involved in these meetings. And so sometimes you just need to take a break. So the parent is then offered a single opportunity to recess for up to 10 school days, unless the committee agrees to a longer time, and then to reconvene to try to come to an agreement again. Sometimes that can be very helpful because you can gather some more information in that time. However, if the student has committed an expellable offense, meaning an offense that might lead to a placement at DAEP, or the student's presence on the campus presents a danger of physical harm to the student or others, the 10-day recess is not required. meaning if there was something significant happened and that resulted to them being placed at DAEP, meaning some like possibly criminal offense or something like that, then you don't have to do a 10-day recess. The ARD committee, if the ARD committee does not reach mutual agreement after that recess, then the ARD committee concludes and the parent is not offered another 10-day recess. The district follows implements the decision based of the school-based members and provides prior written notice to the parent. And at which point the parent does have the right to file due process and all of those things. But at this point, you're answering those two questions. If you end the first meeting not in consensus, you take a recess, then you come back at a later time. And then if you can't come to a mutual agreement at that point, then the ARD is ended and the school implements the decision based off of the school personnel in the ARD committee and then provides prior written notice to the parent. So a new thing that is related to MDRs is that if a student is determined to need out of school placement for more than 10 days, then the district must seek consent from the parent or guardian to conduct what's called an FBA, a functional behavior assessment. And they would do this if an FBA has never been conducted or if the FBA is older than a year old. So they will seek consent. Sometimes parents are like, no, we don't need an FBA. The purpose of an FBA is to determine why did a behavior occur, how often has it occurred, things like that. And so sometimes parents are like, we don't need that right now. And that's okay. Parents can say no to that. The district is just required to say, hey, this happened. We can do a functional behavior assessment if you would like us to. And sometimes it's really actually critical that they do an FBA. It just depends on your situation. So make sure that you're really communicating with your staff in the ARD committee. They would review any previously conducted FBA and BIPs or behavior intervention plans to develop develop any changes. If anything needs to change, they may just need to review some of the data that's already there. They may need to do a full new FBA because this is brand new behavior, or their FBA and their BIP may completely align with the behavior and everyone's like, yeah, that's the student and we're working on it. So it sort of just depends on your student, but this is new for our kiddos. And so if you are involved in an MDR and they're like, we can do an FBA, would you like us to do an FBA? We just need consent. And that's why it's required now. And it's also good best practice to offer that anyway. So what is your job as the parent of the student? Advocate for your student. You need to actively participate in these ARD meetings. All ARD meetings, but especially MDRs when there's a lot of information at work. So you need to provide any information in regards to changes that have happened in the student's life. So have they had a change in mood? Have there been deaths in the family, unemployment in the family, changes in friend groups? Have there been any changes with medication? Have they been on the same medication for a long time and they hit a growth spurt, so maybe the medication isn't as effective? All of those things are critical to the ARD committee to be able to make any type of decision, even in just IEPs. So if there have been changes, definitely communicate that with the rest of the ARD committee. Also, some of our students receive services from counselors, therapists, psychologists, doctors outside of the school. And if there's any information that they have that would help the ARD committee make their determination or even change the IEP to address any concerns that have come up, definitely share that information because it can really be critical in regards to being able to provide appropriate services to our students. Anything else beyond those things, please share, because even it could be just one little thing that you're like, oh, they're acting a little differently the last 2 weeks. Something could have happened on social media that's really bothered them. There are so many things that are impacting our students' lives. And if it's something you're noticing at home, but aren't hearing about at school, that doesn't mean it's not important and not impacting them at school in some way, especially if we don't notice that there's an issue until there's a big issue. Hopefully that makes sense. I know it's a quick, rough run through of what an MDR is. And again, they can be pretty challenging, but really the biggest piece of advice is be active and take your time as an art committee.
Thank you so much, Letitia. We really appreciate your knowledge and expertise today. I am going to launch a poll right now. We would be very appreciative if all of our participants would complete that for us so that we can get some information about how you felt about today's presentation. This helps us in our planning as we're going forward. Also in our chat, I'm going to be sharing a link to some of our upcoming webinars. Registration is available. Our next family webinar is on January 17th, and that is going to be with Lane Pethick, who is one of our consultants here at Region 10. He's going to be talking about brain boosters for kids. He is a fantastic speaker. If you haven't seen him before, I would highly encourage you to register because he is great. But that is our next webinar, and all of our other webinar information is also available on that link that I just shared. If you have other questions about special education, you can always reach out to SpedTechs or to Partners Resource Network to get additional information. SpedTech's website address and PRN's website address I'm going to put into the chat so that everybody has that as well. Jim, do you have anything that you'd like to share before we wrap up today?
Yeah, I was going to ask Letitia a question to clarify on suspensions. Does in-school suspensions count towards those 10 days?
That is a big, depending on the district and how they do in-school suspension. So that's a very big question. And I didn't address it because it depends on how the district and the school structures their in-school suspension. So if students who are in school suspension are receiving all of their services and have the same access to general ed things that they would have had access in the general education room, then that could potentially be an opportunity for it not to count against the student's 10 days. But I always tell districts and staff to be very cautious about that, because in some instances, depending on our students and their needs and their IEPs, that could be very difficult. But it does depend on the district. Some districts have like really amazing, thorough in-school suspension programs that it just astounds me that they're able to do that with staff and all of those things. And then some districts don't. So I don't have the straightforward answer because it does depend.
Thank you for that.
Mm-hmm.
Okay, thank you so much for your time today. We did record today's webinar. With the holiday, I would give this until maybe the first of the year to be posted on the Region 10 website, but the recording will be available there if you'd like to go back and watch this information later. Thank you so much for attending.